purposes of the Sunshine Act, to take public comment.
Good evening. Good evening. Jonathan Kamen, 1806 Frick Building, Pittsburgh, PA 15209. Here this evening on behalf of the interveners. And the reason why I use the term intervener is because, as this board is aware, there is a court case that is pending in the Court of Common Pleas of Washington County, where my clients have intervened in that action. The intervention is an intervention as of right under the MPC, and specifically the applicable section of the MPC provides that a party directly in interest or directly affected by this decision has a right to intervene, and my clients have done that. As a result of that, we are parties to the matter at hand, and believe that any settlement agreement that would be reached by this board and Mark West would necessarily have to include us as parties. The second item I will note is that when Mark West took an appeal of this decision to the Court of Common Pleas, that this board, which sits as a quasi-judicial body, is divested of jurisdiction over this matter. And as a result of being divested of jurisdiction, that means that you have no right to be here tonight to entertain this discussion, or do you have any right to take any further action without the approval of the court. And as far as the approval of the court, you would also need to have the participation of the interveners who are, again, parties to this action. I would also note that this evening's discussion would fall under, as part of your regular meetings, the purview of the Sunshine Act. There was one item of advertised business this evening, which was a discussion on the potential stipulation of settlement, and that public comment should have been given before the board undertook their discussions, deliberations, etc. So we'd also raise an objection to that. So we would ask that the board go ahead and stay any action on this evening, recognize that the action properly belongs where there is legal jurisdiction over this matter, and that is in the Court of Common Pleas in Washington County. Thank you.
Jesse White, 26 White Lane. As counsel for interveners myself, and also being personally an intervener myself, I'd like to first second everything Mr. Kamen said. I raised those same objections, and I hope the board will address them before we leave here this evening. I would also, just procedurally for the record, if for whatever reason you determine that you do have proper jurisdiction, that we would like to make sure that myself and my clients are considered parties in opposition, and we send a letter to your counsel in advance that asking for that, and ask that be placed on the record as well. The only other thing I'm going to mention is in regards to the issue about the three-phase power. My question for the board is, at any point in time, did anybody from the power company actually address this issue? Okay, because, and I think that's really important, because we keep hearing, Mark West has said repeatedly, we can't get power there, we can't get power there. Well, as I've said previously on the record, a couple of years ago, in my capacity as state representative, I reached out to some executives out there in power, and they told me most emphatically that Mark West never requested it. They never even asked. Now, later on in that meeting, I was called a liar by Mark West's representative, but I stand by what I was told. And I think it's interesting that I'm looking at what's happening in Robinson Township. Recently, there were compressors approved there that were all electric, and there was an article in the Observer Reporter just about a month or so ago talking about the power company's commitment, I'm just going to pull up here, talking about the power company's commitment to spend, it says West Bend Power Parent Company, First Light Energy, expects to expend $50 million on new electric transmission projects to support the gas industry in Western Pennsylvania. Now, I remember, this is dealing with the one by, to go to the compressor Robinson. I remember the power company came to me, again when I was still in office last year, and laid out the plan of what they were going to do. So I find it a little hard to believe that somehow they were so willing to be accommodating for Robinson Township, which is more rural than Cecil. Yet they weren't willing to entertain anything in Cecil Township. Yet this board has not asked for one piece of factual evidence other than Mark West's word to support whether or not power would be available there. Now, if you think about it for a minute, if they knew that they couldn't get power there and it wasn't available, they wouldn't have asked for the condition to be removed. Because by definition, they could have used gas compressors. So the fact that they're asking to have it removed, when if they were being honest, they really wouldn't need to have it removed, kind of tells you all you need to know about where their motivations are. And I think that in terms of asking, what the Court of Common Pleas would do or not do and what's considered reasonable, the fact is, I think we would need to look no further than the neighboring township and say, look, they required electric compressor stations. And I can tell you, I spoke with one of the supervisors from Robinson Township privately, and he told me he wouldn't be caught dead with a non-electric compressor station in his township. So I think for all these reasons and more, I think that it would be foolish to drop this requirement. I think not only is it make common sense, secondly, I think we would win at the Court of Common Pleas. And as a party, myself, and representing interveners, that's a position we're going to take as we go forward. I just don't understand what the township gets out of this. Because you made your determination after a voluminous testimony and reasoning, and you guys did a decent job. I mean, this was not an easy task. And you came together and you put together 26 conditions that were reasonable. Mark West then filed a lawsuit, as they have done many times before against this township. And yet they've yet to win one. But they filed a lawsuit and said, we will sue you, and our reward, or in exchange for us not suing you, give us exactly what we want. That's not a negotiation, that's not a settlement. There are other words for that, which I won't say here, but I think we can all think of what they are. So I think that this board, assuming that there is, our issues on jurisdiction are set aside, I think you should stand by what you originally decided. I think the taxpayers will support you. I think the township will support you. I know as an intervener, I will support you. Because barring any evidence to the contrary, there is not one shred of actual evidence that Mark West actually sought electric for those compressor stations. And there's even less evidence that West Bend Power said it wasn't available. Thank you.
Doug Rosinski, 111 Ashland Court. Good evening, guys.